continue for the further cultivation. Because then every time you have to purchase it from the agrobiotech company. But so far the traditional practices is that the farmers, there is also a question that when for our food supply, this is also a question. Another question, that is the use of certain technology. That is, here I mentioned one terminator technology. There is another technology which is known as the verminator technology. Due to the shortage of time, obviously I am not going to discuss the details about this technology. But let me tell you, these are the certain technologies used by the agrobiotech company in order to retain the monopoly. In order to retain the monopoly. Now, if we look into the global perspective, because after hearing up to this, maybe some of you may ask this question that okay, is it compulsory for us to grant intellectual property rights? First of all, let me tell you this thing that this intellectual property law, it is very much it has been highly globalized. The globalization, and so far the economic globalization, actually globalization, it is a process which involves so many things, and out of this is one of the particular area. And under the WTO system, the TRIPS agreement, that is the trade related intellectual property rights agreements, article 27(3)(b), it says that the member shall provide, the word they used in this particular section, that the WTO members shall protect the plant varieties. That means the plant varieties which you can make through the active use of agricultural biotechnology. Okay. Now, these plant varieties are to be protected either by patent or by an effective sui generis system. And ultimately, we have in India adopted a different system. We did not allow the patent protection for the plant variety. Rather, we have made a different law, that is a sui generis legislation. Since I kept the topic as an open one, I am not discussing the Indian legal position. But broadly speaking, this is the summary of plant protection system in Asia. If we look into the the system, that how the agricultural biotechnology is being protected, patent, through patent it is protected, through UPOV it is protected. But if you go through the sui generis system, it in large number of countries, they took that sui generis system of law. Rather than protecting it through the patent, majority of the countries in the South Asian country or the Asia, they enacted the sui generis legislation. And there is no hesitation to say that Indian legislation on this, that is the Plant Variety Protection and Farmers' Right Act 2001, it is one of the most prominent and the vibrant legislation in this particular area. Now, what is our position? Now let me, focus a little bit to my own country. Okay. So far the Indian bioeconomy is concerned, if we look into this bioagri, the total value Indian bioeconomy, it is 62.5 billion in the year 2019. And bioagri, it is 5. Okay. Sorry, bioagri, it is 12. Okay. If we look into the segment, the highest one, that is the bioagri. Okay. And, if we look into this particular entire scenario, that is the industry revenue, it is 12 billion. There are 1 million people, they are directly working in as a biotech workforce. In India, there are 2,500 biotech companies which are working relentlessly. And there are 15,500 graduates, biotech graduates, who are passing out from the different universities in the country. So from this viewpoint also, this is also a very, remarkable thing, that actually we must give some sort of protection, some sort of incentives, okay? Because one of the basic argument of intellectual property protection is that, it gives incentivization. But it is also argued that incentivization, it has been very nicely said, it is a title of an article, that incentivization is maybe the father of the IP, of innovation. but it should not be, it is said like that: necessity is the mother of all innovation, but incentivization need not to be the father of that. I repeat that necessity is the mother of all innovation, but incentivization need not to be the father of that. So that incentivization theory, though it has been criticized, but it is mostly accepted argument behind the IP system. Now, the projection, if we look into the India's biotech industry projection, in the year 2018, it was 51 billion. And in the year 2025, it is expected it is going to be a 102 billion industries, US dollar industries. So obviously, we must look into its protection. This is the case I was talking about. That is, this is a particular potato, the commercial name of license. They again cultivated it.